Hello and welcome to the California Chemical Regulations Overview presentation. I will be talking about some chemical regulations and some health and safety projects that are going on in California that are important to be aware of if you are interested in doing any type of business in the state of California. A general overview of the topics listed on this slide will be presented. So we can't talk about California without talking about Proposition 65. Prop 65 was enacted to protect citizens and the state's drinking water sources from chemicals known to cause cancer, birth defects, or other reproductive harm, according to California's Office of Environmental Health Hazard Assessment, or OEHHA. The list of substances identified as harmful under Proposition 65 is required to be updated at least yearly by the state of California, but there are usually multiple updates per year. After a chemical is listed, businesses have 1 year to comply with warning requirements. It can be helpful in describing what Prop 65 is by also talking about what it is not. Prop 65 is a disclosure law, a right-to-know law, and a notice law. It is not a personal injury law. It's the notice of the presence of a chemical which is known to cause cancer or reproductive toxicity. It is not a notice that the product is harmful. It is not a law that prohibits products from being sold. It is a requirement to warn, which may take the form of a label, billboard, newspaper, and so on. How do scientists determine if a chemical has a risk of causing cancer? A quantitative risk assessment is performed to determine if significant risk exists. No significant risk shall be one which is calculated to result in one excess case of cancer in an exposed population of 100,000, assuming lifetime exposure at the level in question. In other words, if any more than 1 in 100,000 cases of cancer, excess cancer are found, then the chemical is a risk. I wanted to include this snapshot of a piece of the actual list of chemicals to show and reiterate that this is just a list of chemicals and does not include any numerical guidance levels. It includes only a very minimal amount of information, the type of toxicity, CAS number, and date listed. So where are the numerical guidance levels? Safe harbor levels are a tool to guide businesses in determining whether a warning is necessary. To comply with Prop 65 requirements, if you expose Californians to chemicals on the Prop 65 list, you must provide a clear and reasonable warning before exposing anyone to the chemical unless the exposures are so low as to create no significant risk of cancer or are significantly below levels observed to cause birth defects or other reproductive harm. Expose means to cause to ingest, inhale, contact via body surfaces, or otherwise come into contact with a listed chemical. I want to bring up a note for you to start thinking about that will be discussed further a little later in the presentation, and say that it is important to evaluate concentration and usage of the chemical in question. For example, in a workplace, you may need to determine the number of hours per day someone is exposed to the chemical in question, and at what concentration it is typically present. And this is when evaluations of these chemicals can start to get complicated. In the role of Prop 65 implementation, OEHHA has developed Proposition 65 Safe Harbor Levels. Title 27 of the California Code of Regulations prohibits companies that do business within California from knowingly discharging listed chemicals into sources of drinking water. Safe harbor levels are levels of exposure that trigger the warning requirements. Proposition 65 safe harbor levels include no significant risk levels for carcinogens and maximum allowable daily levels for chemicals that cause reproductive toxicity. A maximum allowable daily level represents the no observable effect level for each chemical divided by 1,000. When no human studies are available, a no observable effect level is calculated as the highest dose level that results in no observable reproductive effect, expressed in milligrams of chemical per kilogram of body weight per day. The animal no observable effect level can then be converted into human oral, inhalation, or dermal dose depending on the type of relevant animal study that it is derived from. I wanted to make a note that the safe harbor levels are for exposure and do not correspond directly to concentration in a product. OEHHA has established over 300 safe harbor levels to date and continues to develop more levels for listed chemicals. Prop 65 lists around 800 chemicals, so keep in mind that there are about 500 chemicals listed on Prop 65 which do not have a safe harbor level. MADL and NSRL lists of chemicals can be found in ChemADVISOR's LOLI database. What all of these numbers and tables are trying to help us figure out is if we need a warning. Like we talked about in a previous slide, if you expose Californians to chemicals on the Prop 65 list, you must provide a clear and reasonable warning before exposing anyone to the chemical. But if your business employs less than 10 people, you don't need to worry about the warning. Other exemptions from warnings include governmental agencies and public water systems. Title 27, Article 6, Section 25603 states, the warning materials, be it signs, notices, menu stickers, or labels, are to be provided by the manufacturer, producer, or packager of the consumer product rather than by the retail seller. The Prop 65 warnings must disclose that a product which contains a chemical on the list may cause cancer or reproductive toxicity. A responsible party must not knowingly expose people to a product that contains a Prop 65 chemical. There are 3 exemptions listed in Section 25249.10. Warning requirements will not apply to an exposure for which federal law governs a warning in a manner that preempts state authority. It will not apply to an exposure that takes place less than 12 months subsequent to the listing of the chemical in question. And they do not apply to an exposure for which the person responsible can show that the exposure poses no significant risk, assuming a lifetime exposure at the level in question for the substances known to cause cancer or reproductive toxicity. We will come back to this exemption in a later slide. Details about clear and reasonable warnings can be found in Article 6 of the Proposition 65 regulations. Coming up in the next slide, I will discuss some specific warning requirements. Different types of exposure require different types of warnings. Consumer products includes the most detailed regulations because it includes a broad range of subcategories, each with their own warning requirements. Some of these exposure categories include food other than alcoholic beverages, fresh fruits, nuts, and vegetables, prescription drugs, exposure resulting from emergency or urgent medical or dental care, and alcoholic beverages. Details under CCR Article 6 include specifications regarding the sizes of the required warnings and signs, where they should be placed, and frequency of public media announcements which can depend on the type of exposure, be it in the form of consumer products, occupational exposure, or environmental exposure. The location of the warnings on consumer products is something up to the discretion of the responsible party. It should be placed where it is likely to be read and understood by an ordinary individual under customary conditions or use of purchase. This may mean the warning sometimes appears on the product's label. It can appear on a sign, shelf labeling, menus, or a combination of these. On the warning, wherever it may be placed, it must include the word warning in all capital letters, language that indicates the type of harm, whether it be cancer, reproductive toxicity, or other birth defects. In the workplace, the warning must be prominently displayed. If it is on a sign, it should be posted in a conspicuous place and under conditions that make it likely to be read and understood by employees. The content of the warning messages should contain, for example, warning in all capitals, this area contains a chemical known to the state of California to cause cancer. As we can see in the examples listed here, there are some differing requirements for the color of your warning. There are also suggested sizes and proportions listed in Article 6 of the CCR. Environmental exposure warnings have a few more options for how they may be conveyed. They may be located on a sign in the affected area. They may be delivered or mailed to each occupant in the affected area, but this must be done at least once every 3 months. Or they may be provided in public media announcements which target the affected area. This announcement also must be made every 3 months. The example warning here goes above and beyond the baseline requirements for what you need in an environmental exposure warning, but it is helpful in its detail. Now, if you don't want to use a Prop 65 label or don't think you need one, we're going to talk about what you need to do. If there is no safe harbor level for a chemical, businesses that expose individuals to that chemical would be required to provide a Prop 65 warning unless the business can show that the anticipated exposure will not pose a significant risk of cancer or reproductive harm. OEHHA has adopted regulations that provide guidance for calculating a level in the absence of a safe harbor level. These regulations are Article 7 and Article 8 of Title 27 California Code of Regulations. It is each respective business's responsibility to determine if it is causing exposure to a listed chemical such that it would need to provide a warning under Prop 65. Businesses may find it helpful to consult with a toxicologist or laboratory that is familiar with Prop 65, in addition to consulting with legal counsel. There are no specific protocols or testing requirements. Determining anticipated levels of exposure to listed chemicals can be very complex. Although a business has the burden of providing a warning that is not required, a business is discouraged from providing a warning that is not necessary and instead should consider consulting a qualified professional if it believes an exposure to a chemical may not require a Proposition 65 warning. In summary, you wouldn't want to put a warning on a product of yours that isn't actually harmful, even though it may contain a small amount of a Prop 65 chemical. But it can be expensive to get all the testing done, so there may be extraneous Prop 65 warnings in California. The regulations create kind of a conservative approach towards providing warnings. It can also sometimes be quite difficult to conduct these studies. Those that require continuous monitoring can be burdensome. We have concluded our discussion on the current Prop 65 regulations, and next I will discuss some anticipated changes. OEHHA has issued its proposed regulation to update the CCR's Clear and Reasonable Warning section. This update will change the requirements for warning labeling on consumer goods. The revised warning labels will need to include a yellow triangle pictogram containing an exclamation point and a black border. The warning statement would need to state that the product can expose the individual to a listed chemical, rather than the current phraseology, which specifies that the product or facility may contain chemicals. The proposed regulation specifies 12 key chemicals dubbed the Dirty Dozen, which would need to be specifically identified on the warning. Almost all warnings will require a hyperlink to a soon-to-be renovated OEHHA Prop 65 website, which will provide supplemental information about the warning. The warning would need to be presented in additional languages if the product label otherwise displays them for any other purpose. For example, warning for Canadian products would need to be in English and in French. There will be a 2-year phase-in period if this regulation is adopted. There was a public hearing on January 13th, 2016, and at the end of the written comment period was on January 22nd, 2013. They are now working to create the final amendment for the November 2016 deadline. If this goes according to the timeline, the warning would be required starting in 2018. However, companies are free to update their warnings during this transition period before the enforcement date of the regulation. I have provided the link to the proposed regulation text if you would like more detailed information on this proposed amendment. This concludes the discussion on Prop 65. California Air Resources Board will be the next topic. I will touch on California Air Resources Board, but for more detailed information on this topic, please see ChemADVISOR's YouTube channel for a free presentation about United States VOC regulations with an emphasis on CARB regulations. The link on this slide will take you directly to the presentation video. The California Environmental Protection Agency Air Resources Board puts together regulations to limit the content of volatile organic compounds, toxic air contaminants, and greenhouse gases emitted from the use of consumer products. Some of the consumer products that are regulated include antiperspirants, deodorants, aerosol coating products, hairsprays, cleaners, air fresheners, and adhesives. The purpose of the VOC regulations is to reduce the smog levels. As defined by CARB, smog is a combination of smoke and other particulates, ozone, hydrocarbons, and nitrogen oxides, and other chemically reactive compounds which, under certain conditions of weather and sunlight, may result in a murky brown haze that causes adverse health effects. California's topography, warm sunny climate, and location of majorly populated areas are the perfect components to create and trap smog. Cities are mostly built on plains or in valleys with surrounding mountains that trap the air pollution in these natural bowls, which prevents air and pollutants from circulating and dispersing. A list is found for each of these California air regulations related topics in ChemADVISOR's LOLI database. I will briefly mention a few key points about some of these lists. First, the MIR list. Reactivity limits were developed for aerosol coatings based on the maximum incremental reactivity, or MIR, scale. It pretty much describes numerically how likely a chemical compound is to react in the atmosphere to form ground-level ozone. Next, the air toxics hotspots list. Lists of chemicals where their releases may create localized concentrations or air toxics hotspots where emissions from specific sources may expose individuals to elevated risks of adverse health effects. In LOLI, there are lists included specifically for the South Coast Air Quality Management District and the San Diego Air Pollution Control District. There are 35 local air quality agencies in California. Districts provide local expertise and knowledge of local conditions to deal with local problems. They are governed by boards consisting primarily of elected officials and are staffed by engineers, planners, attorneys, inspectors, meteorologists, chemists, and technicians. In general, these local districts are responsible for control of stationary sources of emissions. While mobile source emissions are mostly controlled by the state and federal regulations, local districts do have authority to implement control measures which affect transportation sources, including automobiles. Local district activities are overseen by both the state and federal agencies. As a result of the Green Chemistry Initiative, 2 legislative bills were signed into law in 2008 to implement 1. The acceleration of the quest for safer products, and 2. The creation of an online toxics clearinghouse. These 2 legislative bills comprise the Green Chemistry Law. When the Green Chemistry Law was passed, the DTSC began to adopt regulations to establish a process to identify and prioritize chemicals in consumer products and to establish a process for evaluating chemicals of concern in consumer products and their potential safer alternatives. According to the DTSC, green chemistry is the idea of designing chemical products and product-making processes which use less hazardous substances. The goal is to protect consumers, create less waste, and promote pollution prevention. Candidate chemicals are a result of the Green Chemistry Law. A candidate chemical is a chemical that exhibits a hazard trait and/or environmental or toxicological endpoint and is either found on one or more of the authoritative lists specified in Section 69502.2. The purpose of the candidate chemicals list is for the DTSC to identify chemicals of concern in priority products. Now it's time for a little bit of history. The DTSC's Safer Consumer Products Regulations took effect on October 1st, 2013, when the initial candidate chemicals list was published. The priority products list was published on March 13th, 2014, and contains consumer products identified by the DTSC, which contains one or more candidate chemicals. Most recently, on June 17th, 2015, the informational list of candidate chemicals and chemical groups was published. Note that the photo on the slide was published by the DTSC in January of 2013. The publication of the informational list of candidate chemicals poses no requirements on the manufacturers of products that contain the candidate chemicals. It is important to note that although the candidate chemicals currently impose no requirements, it doesn't mean that these will not become a chemical that is contained in a priority product in the future, and therefore would have the regulations associated with it. So it may be important to keep in check how many of these candidate chemicals you are using in your products. At this point in time, there are only 3 priority products on the initial priority product list. The DTSC placed these products on the initial priority products list based on 2 criteria in the SCP regulations. 1, the products have the potential to expose people or the environment to one or more candidate chemicals. And 2, the exposure has the potential to contribute or to cause significant or widespread adverse impacts. So what do you have to do if you are a responsible entity for at least one of these products? You must submit a priority product notification to the DTSC within 60 days of the effective date from the chemical being added to the list. You may also need to prepare an alternative analysis. In this process, the existing priority product is compared with potential alternatives such as chemical substitution or product redesign at each stage of the product's life cycle. The findings of the alternative analysis will determine what regulatory response, if any, is necessary. Here is a helpful flowchart of the basic processes for determining candidate chemicals, determining their priority, putting a product through the alternative analysis process, and possible regulatory responses to the alternative analysis. There is no required template that responsible entities must use to present their alternative analysis. You may present the data in the way you feel would provide a clear visual comparison between products and alternatives. Pictured here is an example template provided by the DTSC. Biomonitoring California is a collaborative effort of 3 departments in the California state government and was signed into law in 2006. Biomonitoring is a measurement of chemicals or their metabolites in a person's body fluids or tissues, such as blood or urine. It tells us the amount of the chemical that actually gets into people from all sources, for example, from air, soil, water, dust, and food combined. Because of this, biomonitoring can provide useful information on how much exposure to toxic chemicals a person has had. The purposes of this program are to 1. Determine levels of environmental chemicals in a representative sample of Californians. 2. Establish trends in the levels of these chemicals over time. And 3. Help assess the effectiveness of public health efforts and regulatory programs to decrease exposures to specific chemicals. Designated chemicals are lists of chemicals that should be considered for biomonitoring. The Scientific Guidance Panel is a group of 9 expert scientists who review the program design and implementation and make recommendations on the chemicals to be biomonitored. Some of the chemicals on these 2 biomonitoring lists overlap. Both the designated and priority chemicals lists can be found in the LOLI database. When companies evaluate their priority products and alternative options, ideally, safer alternatives are found and approved. In these cases, the chemical may be able to be removed from the product if it is not necessary, replaced by a safer chemical, or replaced by a safer non-chemical. After any of these options, no further regulatory response would be needed. But listed on this slide are the possible regulatory response outcomes of an alternative analysis when a safer alternative is not readily available. Also pictured is another helpful flowchart which outlines the process SPC uses to help companies make safer products. This concludes our discussion on California chemical regulations. How can ChemADVISOR help you? ChemADVISOR can help identify products sold and/or manufactured in California. We can identify how California regulations apply to the substances in your products. We can develop a compliance plan. We can implement the compliance plan. Please follow our ChemADVISOR blog for more updates, or contact us at info@chemadvisor.com or at the number listed for more information. Thank you.